Swayam Prabha. Digital India. Educated India.
We had mentioned that there are two types of declaratory suits that can be filed under the Patents Act, and this was in the context of 104, where 104 refers to three types of proceedings. One, a suit for declaration under 105, or a suit for declaration under 106, or an infringement suit cannot be filed in a court that is inferior to a district court. We saw that in 104. And we have already seen infringement cases, what can be done in infringement cases, what are the different reliefs, defenses, damages, how damages can be computed, certificate of validity, scientific advisors, and a whole lot of things that usually come up in an infringement suit. Now, in a declaratory suit, the relief a person claims is different from that of an infringement suit. We had already seen in an infringement suit, the patentee would ask for broadly two reliefs. One is a relief to stop the infringing activity, what we call infringement, or compensation by way of money, what could be referred to as damages or account of profit. These are the two broad reliefs. Now, the infringement suit is filed by the patentee to enforce his patent. Law provides for certain declaratory reliefs or declaratory suits where a person who apprehends an infringement action, which means the person who could be the potential defendant or the potential infringer in an infringement suit, to proactively approach the court and get some relief from the court. So, we call them pro-competitive provisions of the Patents Act. The Patents Act promotes competition. At the same time, the Patents Act also grants a monopoly to the patentee in such a way that the patentee can guard his rights, but there could be instances where in the process of enforcing his rights, the patentee could lead to certain abuses. Those abuses could pertain to abuse of use of a patent, or it could also be abuses pertaining to competition laws. So, 105 talks about a preventive action a potential infringer can take even before the infringement suit is filed against him. Now, what is that relief? In 105, the potential infringer can approach the court and make a declaration or seek a declaration that the process that he is using does not constitute infringement. So, it is a declaration of non-infringement. So, we had already mentioned the defendant in an infringement suit can claim the defense of non-infringement. So, the defense of non-infringement is just a defense. A person alleges infringement and you state that I am not infringing, what I am doing is different, or the patent's scope of the patent does not cover the activity I am doing, maybe a product that I am manufacturing or a process I am using. The scope of the patent or the boundaries of the patent does not cover my activity. This is the defense of non-infringement. A declaration of non-infringement is where you ask the court to grant you a relief. In a defense, you are not actually asking for a relief, you are only asking the court not to grant the relief of infringement. There is an infringement that is alleged, you just cite that as a defense, you say that what you are doing is non-infringing. You do not ask the court to give or to declare that your process is non-infringing. You do not do that, you just defend yourself by saying that your process is different. But in 105, you are entitled to get a declaration by, say, requiring that the process used by the person or the making, use or sale of any article by him does not constitute infringement of a claim of a patent against the patentee. Now, to do this, the patentee should be first approached by the defendant by way of writing, and you can see in section 105(1) there is two requirements, A and B. The plaintiff, which is the potential infringer, the plaintiff has applied in writing to the patentee or exclusive licensee for a written acknowledgement to the effect that the declaration claimed, and has furnished to him with full particulars in writing of the process or article in question. So, before approaching the court, it is a pre-requirement that the potential infringer had written to the patentee saying that I am adopting a process or I am manufacturing an article, and this process or this article does not infringe your patented process or article. So, and he should approach the patentee asking for an acknowledgement in writing. So, the potential infringer writes to the patentee and for a written declaration. So, if the patentee gives a written declaration, then there will not be any infringement suit based on the action of the potential infringer. So, it is one way to avoid litigation. So, he writes to the patentee, and B, the patentee or licensee has refused or neglected to give such an acknowledgement. So, that is the reason why the potential infringer approaches the court. He had asked for an acknowledgement stating, disclosing what he is doing and asking the patentee to give a declaration that what he is doing is different. It is not covered by the patent and hence it is non-infringing. The patentee or the exclusive licensee refuses to give such a declaration. Once there is a refusal, then the potential infringer can approach the court with a declaratory suit under 105. Now, there is also a provision under section 34 of the Specific Relief Act where you could generally get reliefs on declaration. If there is dispute with regard to a person's marital status, there are instances where section 34 has been employed, or any dispute with regard to a person's right or a title. It is a very broadly worded provision. So, this provision is notwithstanding anything contained in section 34. So, this operates on a separate level. So, whatever is contained in section 34, independent of that, this provision will cover instances where you need to get a declaration pertaining to a patent. 105(2) states that the costs will be borne by the plaintiff unless there is a reason to decide or to adjudicate otherwise. And in this proceeding, importantly, the validity of a claim of a specification shall not be called into question for a declaration brought by virtue of this section, and accordingly making or refusal of such a declaration will not have any bearing on the patent's validity. It shall not be deemed to imply that the patent is valid or invalid. What this means, when you are seeking a declaration on non-infringement, you are not touching upon the validity of the patent. Rather, you are going to interpret the claim of the patent and see whether the disclosed process or article falls within the scope of the claim. That is it. The entire proceeding is simple because the task of the court is to interpret the claim as claimed in the patent and to see whether the article that is being disclosed or the process that is being disclosed by the potential infringer falls within the scope of what is being claimed. If it does not fall within the scope, the court will grant a declaration that this process is non-infringing. And a plaintiff in this case, which is a potential infringer or a defendant or a potential defendant in an infringement suit, cannot raise issues of validity, because the object of this proceeding is not to look into the validity of a patent. It is rather to look into the claim made by the potential infringer as to his process or product being different from what is patented. So, the analysis here is to look at the patented process or product, which is the claim, and see whether what the potential infringer has disclosed in the suit will fall within the scope of that. It's largely an affair of interpreting the claims of the patent and understanding the scope of what is being disclosed by the potential infringer and doing a mapping. It does not, you cannot raise issues of validity, questions or grounds under section 64 cannot be raised in these proceedings. Now this suit can be brought after the publication of the grant. So this is a post grant proceeding, in the sense that you cannot claim a declaration of non-infringement of a patent that has not been granted. So this is the first type of declaratory suit, where a person who apprehends an infringement action against him, because that's the only reason why you need to get an declaration of non-infringement. So that is why I have been using the word a potential infringer. A potential infringer can go to the court and get the entire way cleared by saying, or by getting a declaration from the court that what he is doing is different from what is patented, so that he can preempt injunctions that can come along with an infringement suit if there is a chance that the patentee could enforce the patent against the potential infringer.